sued your doctor for medical malpractice, claiming that he was careless and caused you significant harm and injury. What does it mean now during the course of your lawsuit when I have a chance to question the doctor at a pretrial question and answer session known as a deposition? If at the end of that deposition, I now turn to the defense attorney and I say, do me a favor, call the carrier and see what they want to do. Want to know what that means? Come join me on this walk along the beach as I tell you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. Your doctor denies all of your allegations. Now, prior to starting your lawsuit, we are required, in fact we did, have a medical expert review all of your records who confirmed that yes, your doctor was careless and violated the basic standards of medical care, and that carelessness was a cause of your injuries, and that your injuries are significant and permanent. Only then are we permitted to go ahead and start a lawsuit on your behalf. During the course of your lawsuit, I will have an opportunity to go ahead and question the doctor whom you have sued, and the process known as a deposition. That's really a question and answer session that takes place in the attorney's office, in the doctor's attorney's office. Now, during COVID times, this typically takes place over a Zoom video call. The doctor and his attorney will be in one room. I will be on the video. A court stenographer will also be on the video call to record all of my questions and all of the doctor's answers. The answers that the doctor gives represents his sworn testimony, and it carries the same exact weight as if he is testifying at the time of trial in front of a judge, in front of a jury, in court. So now, during my questioning, I'm able to learn critical information. I'm able to get admissions from the doctor about things that he did, as well as what the standard of care was in treating a patient with this type of problem. And if your testimony is to be believed, then more likely than not, the doctor would have violated the standard of care for doing exactly what he did. Assuming I'm able to get the doctor to make those admissions, which in some cases I'm able to do, now at the very end of questioning, before we get off the Zoom video call or before I leave the attorney's office, I turn to the defense attorney and I say, hey counselor, do me a favor, contact the carrier and see what they want to do. What does that mean? I'll tell you what it means. When we are done with the doctor's questioning, with my questioning of the doctor during this deposition, the defense attorney will prepare a report that he sends off now to the doctor's insurance company. He not only prepares an analysis of what the doctor said, but he explains to the insurance company whether or not our claims are believable and whether or not there is a risk of going to trial. If there is a significant risk of them going to trial, now the attorney may suggest that it's time to start negotiating your particular case, to see if they can try and resolve this case, try and settle it before it goes all the way to trial, before we continue taking these depositions. Now, why would they do that? Because it may be financially better for them to try and settle a case now rather than wait 6 months, a year, or 2 years down the road when they will have to spend more and more money to defend the case, knowing full well that they may have to try and negotiate or settle the case at the end anyway. So if they could try and do that now because they recognize that there is a significant risk that if they do go to trial down the road, that it's better to try and settle the case, it may be beneficial for them from a financial perspective to try and settle it now for 2 reasons. One, if they try and settle it now, they can probably do it for less money than they would have to do it at the time of trial. Because now, by the time we've gotten to trial, each side has now prepared extensively. Each side has now spent a great deal of time, energy, resources, money to go ahead and get the case ready for trial because you simply don't know whether or not the case will settle. And since you don't know that information, the attorneys on both sides now have to gear up and get ready for trial. So the goal of trying to entice the attorney to reach out to the insurance carrier, the insurance company, to see if we can get settlement negotiations going because the doctor has just given damaging testimony. That is a great way to get settlement discussions going. And if I am correct in my assessment of how poorly the doctor did in response to my questions, now there is likely a greater incentive for the defense lawyer to let the doctor's insurance company know that information now so they can start to assess this, assess their risk, and start to negotiate earlier rather than later. So why do I share this quick information with you? I share it with you because I have a few minutes to myself on the beach. My wife is all the way in the distance picking seashells, and I thought it would be eye-opening to help you understand how these types of cases work in New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you're thinking about bringing a lawsuit but have not done so yet, and you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.